progress.
Shalom. This is our first video in the series on Halachic estate planning. And in this video, I'd like to discuss some of the more basic principles of Yerusha al-pi Torah. These principles are very, very relevant in understanding the different approaches of the various poskim regarding the latitude that's available to us in planning and executing a plan regarding the division of our estate. Let me explain. Anytime I wish to transfer my property to someone else, I do a maaseh kinyan. I do an act of kinyan, and I transfer the property from myself to that person. When I pass away, I can't obviously make a kinyan. I can't transfer my property to my heirs because I have passed away and I'm no longer in control of my assets. How is it that the assets, in spite of that, pass to my heirs? I have made no kinyan. I have made no executed no act which results in the transfer of my assets to someone else, to my heirs, for that matter. How does that work? The answer apparently is that there is a separate institution legally called inheritance. And in the context of inheritance, although I do no act at all to transfer the property, the rule of inheritance applies at the moment of death, and the law transfers my property from myself to my heirs. So is it also in al-pi din Torah. Al-pi din Torah, I do no kinyan when I die, obviously, and yet the property passes from my ownership to the ownership of the heirs as determined by Torah law, and it's the Yerusha itself which causes this transfer to take place. If Yerusha thus was only an alternative to kinyan, if it was just another way of transferring property, then it would appear that there's nothing inherently significant about the idea of Yerusha or about the determination of who it is that inherits. It's a technical tool which replaces kinyan, which makes possible the transfer of my assets to someone else, even though I've done nothing positively to do so. If that were the case, if it was just what we would call dinei mamonot, if it was just another chapter in the overall rules of property transactions, then it seemed to be a totally technical issue. But that's not the case. As we'll see as we work through these sources, Chazal have always considered Yerusha to be a lot more than just a technical means for transferring assets from A to B. The idea of Yerusha has inherent purpose, and that purpose, that content, creates a different approach completely to the meaning of Yerusha, and therefore to the latitude which halacha will allow us to deviate from the prescriptions of halacha. The more that we find that Yerusha has inherent purpose, the more that we find that there are particular halachic considerations, or even more significantly, not halachic considerations, but if there are significant moral issues at stake in the passage of my estate from myself to my heirs, the more weight that we give to those considerations, the less halacha will be willing to allow for deviations from that order of inheritance. I think that idea should be very clear. The more that there is inherent significance in the order of inheritance, the more that the Torah gives weight to the particular way in which my estate is divided because of principles that we will discuss, the more weight that the Torah allocates to such principles, the less halacha will be willing to deviate from those principles. If it was purely an alternative for transferring property, then halacha wouldn't have very much to say about who it is I transfer my property to. Just as during my lifetime, I can transfer property to anybody I wish. If Yerusha was just an alternative for transferring property, then there wouldn't be very much for halacha to say about it. But as I said, that is not the case. Yerusha is qualitatively different from transfer of ownership during lifetime via kinyan. Yerusha, we will find, has inherent significance, and it is that inherent significance which colors the entire sugya of halachic estate planning. So let's get into the sources that we're going to take a look at. The first is in Parshat Pinchas. In Parshat Pinchas, we find Benot Tzlafchad, the famous story of the daughters of Tzlafchad that petitioned Moshe Rabbeinu for a psak halacha regarding their status as the heirs of their father, since they were all daughters and not sons. The parsha begins with the instructions that HaKadosh Baruch Hu conveys to Moshe regarding the division of Eretz Yisrael. And at this point, I should point out that there's a link below that you can use to download the source sheet, which contains all of the content of the slides that we're going to be seeing. So you can download the source sheet, print it, or keep it on your screen. You can look at it afterwards to review after we finish the lecture. Free to download and use any way you see fit. וידבר שם משה לאמור לאלה תחלק הארץ בנחלה במספר שמות. Here's the way in which Eretz Yisrael is supposed to be divided. לרב תרבה נחלתו, למעט תמית נחלתו. The more population there is in a particular shevet, the larger his share should be. Ish lefi pekudav yitei nachlato, according to how he's counted. But on the other hand, ach begoral yechalek et haaretz. Eretz Yisrael will be divided by goral. According to the names, lishmot matot avotam yinchalu, according to the patriarchal families of each of the shvatim. The specifics as to how these work together in order to produce the result of Chalukat Haaretz, a very, very large sugya in Baba Basra, in the 8th parak, Parak Yesh No Chlim, which is the primary parak dealing with all matters of Yerusha. We won't get into that. That's a separate sugya worthy of analysis in and of itself. We're looking at the ramifications of this pasha for our own estate planning. So we will continue and take a look at how this affects halacha l'maaseh. Tikravna benot Tzlafchad ben Chefer ben Gilad ben Machir ben Menashe l'mishpachot Menashe ben Yosef. They approached, and these are Lishmot benotav, 5 daughters, Machala Noach, Aglam Milka, Uvitirtza. Tamod lo lifnei Moshe, and they stand before Moshe, lifnei Elazar Kohen, lifnei Nisiyim, v'chol ha'edah. This was a major assemblage of all of the leaders of the Am, who were the poskim of the Am, as well as the Eidah itself, Petach HaMoed. They present this petition to Moshe. Avinu meit b'midbar. He was not part of the Korach rebellion, but he passed away. He had his own cheshbonot with the Kadosh Baruch Hu. Chazal and analyze what this particular chait was. Again, we won't get into these side issues, but the point here is that Ubanim lo hayulu. Tzlafchad did not have sons. And the question here is whether or not these 5 daughters will inherit when there are no sons. And their claim is, Lama yigarashem avinu mitoch mishpachto ki ein lo ben. Why should our father's name be diminished, whereby his estate will not pass to his descendants just because he has no sons? What about us? Our father's brothers are also heirs of our grandfather, and our father's share, if we do not take, because we're daughters, would then pass to his brothers. And then my father's lineage will be, or our father's lineage will be totally erased. That would seem to be undesirable from the perspective of the daughters. Moshe saw sufficient merit in this petition, and approached the Kadosh Baruch Hu for a psak. And the Gemara discusses what exactly it was that Moshe was not sure about. But again, we'll take the psukim at face value for purposes of our discussion. Hashem says to Moshe, Kain benot tzelav chad. They're 100% right. Naton titen lahem achuzat nachala b'toch achay avim. They will take the share of their father amongst the brothers of the father. In other words, since there are no sons, the daughters will take. At this point, the parsha could have ended. Benot tzelav chad requested a psak halacha whether or not they take the father's share, given that there are no sons. Hashem says, Kain benot tzelav chad dovrot. They're 100% right. They get the share of the father. End of story. But the Torah comes along and uses this incident as a trigger for establishing a more general set of principles regarding the ways in which an estate should be divided. Beginning with the benot tzelav chad situation, but expanding it beyond that. Bel b'nei Yisrael tedaber le'mo. Ish ki yamut. Any man, not just tzelav chad. Ish ki yamut, or any person. Ubein elo, if he does not have a son, as was the case with tzelav chad. Sorry. Va'avarta et nachlat avihen lahem. Va'avarta et nachlat avihen lahem. If there are no sons, as we saw before, tzelav chad, the benot tzelav chad received their nachlat avihen, and similarly, ish ki yamut ubein elo, va'avartem et nachlato lebito. His nachala would then go to his daughter. Implicit in this sentence is that if there is a son, the son obviously takes. It's only ish ki yamut ubein ein lo. If he has no son, then va'avartem et nachlato lebito. And if there are no daughters, in which case we're already moving beyond Parshat Benot tzelav chad. If there are no daughters, then the estate would pass to the brothers of the decedent. And here the Gemara analyzes the question, what about the father of the decedent? What happens if, unfortunately, a child passes away and the father is still alive? Does the father have a right to inherit? And the Gemara establishes the principle that the father does. Not only that, but the father will precede the decedent's brothers. It says here, after daughters comes brothers. The Gemara interjects, before brothers comes the father. And the reason for that is very simple, because as we'll see, the Ramban explains, you can take a look inside and see the Ramban. The Ramban says that inheritance is vertical. If I pass away and I leave children, the estate passes down to my children. First the sons, if there are sons. My son's descendants, if there are. Grandchildren, great-grandchildren on my son's side. If there is no heir in my son's line, then I go to my daughter. Again, vertically for myself, down to my daughter or to my daughter's descendants. If there are no children or descendants at all, then the estate goes up. It either goes down or up. So if I die without children or descendants, it passes up to my father. If my father is alive, he takes. If my father has already passed away, then his descendants will receive the estate. And among his descendants are not only myself, but also my brothers, no brothers, my sisters. So my brothers will take because they are common descendants of my father. If my father is alive, he inherits. If not, then my brothers. So we see that Yerusha al pi Torah is always vertical. Either it goes down, which is the preferable or the priority. If there's nobody below me, then we start to go above me, to my father or to his descendants. If my father is not alive, if he left no other descendants, if I am an only child, for example, then we go another step further up. We go to my grandfather. And if my grandfather is no longer alive, we look to his descendants. His descendants may include my father's brothers and sisters, uncles and aunts, and their children. So we see always the estate goes vertically. In any event, the pasuk itself says if there's no daughter, it goes to the brother. And if my father had no brothers, then I'm sorry, if the decedent had no brothers, then the estate goes to my father's brothers. So by going up another generation. We look for the closest heir existing, and he's the one that Yerusha. And as we'll see, the estate can go even up to the beginning of a shevet. And therefore, there is no ein adam b'Yisrael she'ein lo yoresh, because if you can go all the way up to the forefather of our entire shevet, and we have a Kabbalah and Chazal that there is no such shevet that was entirely extinct. So there must be somebody in the shevet, and it could be the most distant heir that you can imagine. But if that's the first heir available, he will be the one that takes. That's the parsha of Benot Tzlafchad. The relevant aspects of this Seder of Yerusha for most of us will be the first generations below or above. Either my children or my father and my father's extended family. Notice that there is no situation in which a widow inherits. There are other provisions for a widow, al pi halacha. Support, maintenance, residence rights, etc. But the widow does not inherit any actual portion of the estate itself. Similarly, daughters. Daughters do not inherit where there are sons. Again, halacha provides for daughters in such a situation. The sons who inherit would be obligated to provide for the daughter's support, dowry, for example, etc. But again, they do not inherit an actual portion of the estate. And we could already state the obvious. For most people today, in the context of modern society, it is statistically a fact that most, if not all, men who wish to plan their estate would instruct that the estate pass to their spouses. And only after the death of both parents would both parents instruct that the estate pass to the next generation, to the children. Same thing the other way around. If it's the woman that's drafting a will or planning an estate, she would wish for her husband to be her heir if he survives. And only if the husband is no longer alive would the estate then be instructed to pass to children. Such a estate plan is clearly not consistent with this division of the estate, as we just learned. When a husband dies, according to halacha, if he has sons, then the estate passes to his sons, not to his widow. And if his wife is no longer alive when he dies, the estate would pass only, again, to the sons, but his daughters, if he has daughters, would not inherit anything from his estate. So whether or not the intent is that the surviving spouse receive a share, or whether or not the intent is that if there's no surviving spouse, all children divide equally, sons and daughters alike, either one of those, which are usually the case in most estate plans, where somebody gives his or gives it some thought as to how he would like his estate to be divided, and clearly that is not consistent with the decision, with the Torah provisions that we've just learned. One might say that based on what we've seen so far, Kadosh Baruch Hu had given the instructions to divide Eretz Yisrael. In the context of that set of instructions, Benot Tzlafchad present their petition, and Moshe Rabbeinu brings the answer of Kadosh Baruch Hu that they indeed do inherit the share of their father in Eretz Yisrael. And on that basis, the Torah continues, expands. The Nachala, in the first instance, would appear to be Nachala of Eretz Yisrael. The question, therefore, could arise: to what extent does this order of succession, which was designed to implement the division of Eretz Yisrael, to what extent does this order of succession apply even to assets having nothing to do with Eretz Yisrael, to metaltli, to my stock portfolio, or even to my home or my land, but not Eretz Yisrael? To what extent do these same provisions apply in such a case? Perhaps the case could be made that this order of succession is only applicable vis-a-vis Chalukat Eretz Yisrael to the Shvatim. Comes the Ramban and focuses on the very last words of Parshat Benot Tzavcha. Vaytal Bnei Yisrael bechukat mishpat, and kasher tziva Hashem et Moshe. This phrase lechukat mishpat is almost unique in Parshat Benot Tzavcha. There's only one other place in the Torah where this combination of chok mishpat appears as a phrase, lechukat mishpat, and that's in the context of Batei Arei Choma, which we won't get into. But the Ramban makes the point that the fact that the Torah designates the order of inheritance as being chukat mishpat, he therefore interprets it to mean, sheyeh hamishpat hazeh lidorot, lo benachalat haaretz ata bilvad. Chukat mishpat has the element of chok, of chukah, of being an eternal rule that cannot be transgressed, no matter what the underlying considerations might be. So after the Ramban's explanation of this pasuk, we now see that the Torah provisions for division of the estate are eternal. They apply in every generation, whether or not we're dividing Eretz Yisrael or any other land or metaltalin or any assets or any property of any kind. And therefore, these provisions for division of the estate are binding today as well. Halacha l'maaseh. In the next lecture, we'll take this further to see how this plays out among the Rishonim and Achronim vis-a-vis this idea of chukat mishpat and how that will influence the possibilities that will present themselves for in the decisions of the poskim for deviations, if you will, from the Seder of Yerusha as we've seen it in Parshat Benot Tzavcha. Okay, that's it for now. Follow the notifications in the channel, find out when the next video will be uploaded.